Hello everyone, and thanks very much for tuning in for this Christmas edition of Gough Square Live. You can see that Jonathan and I are taking the festive season very seriously. In fact, we've been sharing in the Christmas spirit more or less continuously since Chamber's Christmas party last week, and so we see no reason to stop now. So, cheers.
Cheers.
Oh, that's it, absolutely. Hey, there we go. I won't do the joke. Now, I'm only joking, of course, about the sherry here. It is actually only grape juice, because this is streamed live, of course. Now, in any event, as you may be aware, a brand new edition of the Pink Book went on sale this week, and we have a copy right here. So there's still time. If you're looking for the perfect present for someone special in your life, pick up a copy of the 6th edition of Consumer and Trading Standards Law and Practice. You can't go wrong.
2018 edition.
Right, with the usual Pink Book plug out of the way, we can get on to business. As you may have seen, I've spoken previously about the changes to the primary authority regime. For those of you who may have missed my last talk with Alison Lambert, you'll be able to find it on the Gough Square Live YouTube channel. In that talk, Alison and I discussed 1. The involvement of national regulators in supporting primary authorities, 2. The new default position where primary authorities are responsible for the whole range of regulatory functions rather than just particular categories, and 3. Changes to the definition of enforcement action. Today, Jonathan and I are going to look at a few other topics of interest relating to primary authorities. First, I'm going to give an overview of the new types of primary authority relationship, that's both the new types of authority and the new groups. Then I'm going to talk about advice and guidance and inspection plans. And third, I'll talk a bit about prohibition, particularly the prohibition timetable and enforcement. Then I'll hand over to Jonathan, and he will talk about situations where proposed enforcement action is inconsistent with advice or guidance that's previously been given. Last but not least, Jonathan will move on to discuss the referral process. There's quite a bit to get through, so we'll keep each topic brief. As ever though, please do send us through any questions that you might have during the show. You can either post them to the chat group or on the YouTube channel, which I'll be monitoring, or email them to us directly at goughsqvl, that's Victor Lima, @gmail.com. So, on to the first topic, the new types of primary authority relationship. Could I have slide 1, please? As a result of recent changes, there are now 4 different types of primary authority regulator: qualifying regulators, specified regulators, supporting regulators, and complementary regulators. Qualifying regulators are local authorities. In fact, by definition, all local authorities are qualifying regulators. Specified regulators are those specified by the Secretary of State. So in other words, the Secretary of State now has the power to make anybody with a regulatory function a specified regulator for the purposes of RESA. The idea is to let regulators other than local authorities act as a primary authority if needs be. Supporting regulators were discussed in detail in my last talk with Alison. In summary, though, those are national regulators, such as the CMA, the FSA, and the HSE, who don't have direct enforcement responsibility for the legislation listed in Schedule 3 of RESA, but who will be able to help primary authorities in a number of ways. The sorts of things that the government has in mind are specific hands-on support, such as access to testing facilities and technical knowledge, as well as broader coordination support, such as a wider perspective on inspection plans and national inspection strategies. Finally, there are complementary regulators. That could be any person or body with a regulatory function that is specified by the Secretary of State. The distinction between them and a complementary regulator or rather between a complementary regulator and a specified regulator, is that the complementary regulator can't act as a primary authority.
So simple then.
So those are the new types of authority, but what about the new types of regulated entity? Well, in reality, there's only really one new type of regulated entity, and that's the regulated group. This means that it's now possible for lots of businesses to receive advice and guidance as a group from a single primary authority. The main beneficiaries of this are likely to be trade associations and similar sorts of industry groups. However, in order to form such a group, the Secretary of State needs to sign off on it by nominating the coordinator of the group. It's then the coordinator's job to administrate the group, and in particular, to keep an up-to-date list of its members. That membership list is particularly important because other regulators are only bound by the primary authority group relationship if they're aware that the regulated person is a member of the group. Right, that is part 1 done. On to part 2, which is advice and guidance and inspection plans. Can I have slide 2, please? You'll see there that I've set out section 24A, subsection 1 of RESA on this slide. This is the new provision that came into force on the 1st of October of this year and provides the remit for advice and guidance. Now, of course, one of the criticisms that's been levelled at enforcement authorities is that there was a perceived inconsistency in the frequency and standards of inspections carried out by different premises or at different premises by different local authorities. As a result, changes have been made to RESA so that primary authorities can make approved inspection plans. These plans can limit the scope and circumstances in which an inspection can be carried out by other local authority regulators. Once an inspection plan has been approved and other regulators have been notified about it, other regulators can't then carry out an inspection otherwise than in accordance with the plan. That is, unless the primary authority has agreed to another regulator departing from the approved plan. The important point to note there is that, at least in the view of Jonathan and myself, if an authority carries out an inspection plan that's not in accordance with an approved plan, then that inspection is probably unlawful, notwithstanding the fact that the authority has a statutory power to do so. So it's important to make sure that if there is an approved inspection plan, that it's followed. The final topic I'm going to discuss is prohibition. Could I have slide 3, please? Probably the most difficult question that local authorities will encounter with the scheme is whether a primary authority should prohibit enforcement action from being taken by another enforcer. As viewers will no doubt be aware, a primary authority can do this where it takes the view that the enforcement action being proposed by the other regulators is inconsistent with advice and guidance that the primary authority has given a business or a group. Now, Jonathan is going to talk in a little bit about inconsistency and about what that involves. But before I hand over to him, I'm going to set out briefly the timetable for prohibition. There are 3 stages to the prohibition process. The first is notification, where an enforcing authority formally notifies the primary authority that it wants to take enforcement action. Once that happens, there is an automatic 5-day freeze period during which time the enforcer can't take any action against the business. That gives the primary authority an opportunity to intervene, if it wants to, and prohibit the enforcement authority from going ahead. That prohibition is the second stage of the process. If the primary authority does prohibit the enforcement action, then any action taken against the business is, of course, unlawful. However, if the primary authority chooses not to intervene, then that doesn't necessarily mean that the enforcing authority can get started as soon as the 5-day period runs out. Instead, the third stage kicks in, and that's where the business can apply to refer the matter to the Secretary of State. If that happens, the business then has a further 10-day freeze period, during which time the enforcing authority can't take any action, while the business asks for permission to refer the matter to the Secretary of State. If that referral does in fact go ahead, then the enforcing authority can't take any further action until the referral is determined. Similarly, during both the initial 5-day freeze period on notification and during the subsequent 10-day period while the business asks for permission to refer the matter, the enforcing authority can't take any action, and any action taken will be unlawful and is potentially an abusive process. One thing to bear in mind, though, is that time limits for prosecution aren't affected by these prohibition periods. If enforcement action is prohibited for a period of time, then that period of time doesn't count towards the time limit. In other words, the prohibition periods stop the clock from running, so you don't need to worry about a prosecution becoming time-barred just because of the prohibition process being followed. Right, well, that's enough from me for now. Jonathan, over to you. I believe you're going to talk a little bit about inconsistency.
I am. I have two topics to talk about. Firstly, the most important issue, the critical issue of whether enforcement action is inconsistent with advice or guidance given. And the second is the arbitration process, when there is a dispute about that and other elements of the advice given. And it's critical to understand that these two form the heart of primary authority. The first is quite well known, the second, referral process and arbitration, is not. But I'd like to address both of them through the prism of the main case on primary authority, which is the judicial review case of the Crown on the application of Kingston upon Hull City Council and the Secretary of State for Business, Innovation and Skills, Newcastle City Council and Greggs plc. And some of you will be aware that I represented Greggs plc in that case. That's the only case on primary authority, the only serious appellate case on primary authority, and it concerned the provision of toilets in a bakery. Some would say a very important issue. Greggs had been advised on the law by its primary authority that it did not need to provide toilets where there were 10 or less seats in a store. It was primarily a takeaway store. There was a challenge to that advice by Kingston upon Hull City Council on the basis that it was not legally correct. Their argument was it did not matter how many seats, Greggs must provide toilets because it fell within the relevant legislation and statutory definition. So there was there essentially a dispute between two local authorities. It was not well known at the time, but there is a process under RISA by which you can refer such disputes to the Secretary of State under a referral process, which is effectively an arbitration process. And that's what happened. Hull referred it, and it was determined ultimately by the Secretary of State. Hull lost that process, but then subsequently brought judicial review proceedings on the basis primarily that the primary authority advice was wrong in law, and secondly that the Secretary of State was wrong to uphold it. And ultimately they won that judicial review. So why is that case helpful? It's helpful because it illustrates two parts of the primary authority scheme that are critical. The question of inconsistency, and secondly the referral process, which we need to understand a little bit more because it's likely to become more important as this scheme progresses. So if we can have slide 4, please. Slide 4, we have referred in slide 4 to the test in section 25C4, which used to be section 28. And that is the test which determines whether or not the primary authority may prohibit enforcement action. And it bears repetition. If the primary authority determines within the relevant period that the proposed enforcement action is inconsistent with advice or guidance previously given by it, generally or specifically, it may direct the enforcing authority in writing not to take the action. The rationale for this comes from the Hampton Review on reducing administrative burdens, which reported that a highly fragmented system of local authority enforcement means that business is more likely to be on the receiving end of conflicting advice, which could impose undue burdens. Now this was a highly contentious issue that was debated in Parliament, and indeed during that process there was an amendment which suggested that local authority advice should remain a local democratic decision. But the government rejected that on the basis that it would not provide the certainty that business needs. So the system is one that is designed to be undemocratic in that sense. It's designed to ensure consistency across local authority areas rather than promote local authority decision making. That's the whole rationale of this. So what is meant by inconsistent? Well, it has no special meaning. Its ordinary English usage meaning would be not compatible with or in keeping with. The reality is the test has not been properly litigated yet. It was touched upon in the Greggs case, but that wasn't the primary issue in that case. But there are 4 points that I think are important. Firstly, it's important to understand that this is a discretion. The word may permits the primary authority to block action that is inconsistent with advice or guidance previously given. The word may is important in a statute because it connotes a discretion. And what that really means is that it's not in every single case that enforcement action should be prohibited or blocked. It may be that there are special circumstances that determine that it would be wrong for the primary authority to block the action. There may be specific local factors that militate against prohibition. So it's important for a primary authority to recognise, and for everybody involved in the process to recognise, that this is discretionary and doesn't have to be applied in a binary way. The second point to be made from the wording of the provision is that it uses the words generally or specifically, and that rather suggests that the test provides a broad discretion for the primary authority. Rather suggests that we're not looking here for a direct conflict between the literal words in the advice and the enforcement action. Really, we're looking at the gist, the generality of the position. And so it suggests that the test is wider than simply applying a literal question of whether it is inconsistent or not. The third point that I think is important to make now is that the changes brought about by the Enterprise Act 2016 that came into force in October now place the current primary authority under a duty to take reasonable steps to ascertain whether another primary authority has given advice and guidance that might be inconsistent with proposed enforcement action. And it's quite critical that, because there are now situations where there are many primary authorities acting, and because of the nature of the scheme, business can go from one primary authority to another. They can select a primary authority to deal with, for example, environmental health issues, and have a different primary authority for trading standards issues. So it's critical that primary authorities and also businesses understand that the advice that they receive from any primary authority must be considered in making an enforcement decision. And the final point in relation to inconsistency is one that came directly from the Greggs case, because in that case there were two constructions of a statute, two interpretations of the meaning of a statute, and there was an argument that was raised by the Secretary of State that when there are two equally tenable constructions of a provision, both are deemed, unless there is an authority or a court ruling which says that one is right and the other is wrong, both should be deemed to be correct in law. That was very robustly rejected by Mr. Justice Kerr. He said the primary authority must get the law right. It is crucial that it does so, because the law must be the same for everyone in the relevant market to avoid unlawful distortion of competition. You cannot have one law for Greggs and another for its competitors. And that was a central rationale for it. And so what that means in terms of the way in which primary authorities give advice is that they must be careful to get it right, and particularly because the test that is applied in relation to the referral asks whether the advice was legally correct. So let us move on to that. Slide 5, please. The referral process requires the Secretary of State to give consent to the referral. All three of the affected parties may apply to refer a decision made under the primary authority scheme. So, for example, if the enforcement action is blocked, the enforcing authority can apply under the scheme. If the enforcement action is not blocked, the business can apply under the scheme to say it ought to have been blocked. And finally, if the primary authority just can't decide, it can refer the decision to the Secretary of State for review. So all three parties can, under the referral process, refer it to the Secretary of State, or refer the contentious decision to the Secretary of State. It's important to bear in mind the time limits that Robin has referred to. Each of the parties must make the time limit within 10 working days. In fact, the primary authority has less time to make the decision. It has to do so within the 5 working days of the initial prohibition period. So there is a short time period. This can be extended in exceptional circumstances, but my sense is that will rarely be the case. So everybody is going to have to work quickly under this scheme. It is stated to be subject to the consent of the Secretary of State, so there is a threshold that you must pass before you're entitled to have your decision considered by the Secretary of State again. There is currently no guidance on the basis upon which consent will be given or refused, but it looks to us, or certainly to Robin and I, that this may operate in a similar way to the permission threshold in judicial review proceedings, where permission is often refused where a claim is not arguable, outside the court's jurisdiction, or has been brought after the expiry of strict time limits. I think time limits may be equally important under the referral process as they are in judicial review proceedings. So let's assume that you have your consent and the decision is then taken by the Secretary of State. In the Greg's case, that decision was made on paper, and there were representations made, fairly extensive representations made, as to the 3 elements of the test. What are those 3 elements? If I could just go back to the slide again, please. The first is the question of whether the advice or guidance, or advice and guidance really, was properly given. What does that mean? Well, it's likely to mean that it was given as part of a primary authority relationship that was consented to by the Secretary of State. All primary authority relationships must go through the consent process, and although this may in many cases be a rubber stamp, they need to have a primary authority relationship signed off before advice and guidance will be properly given. This is particularly important now because there are changes in the types of primary authority relationship, and certain primary authority relationships may not have permission to deal with certain types of legislation. So the first question is, was the advice and guidance given under an approved primary authority relationship in relation to a certain type of enforcement action that was approved by the Secretary of State? The second question is whether or not the advice or guidance, generally or specifically, was inconsistent, and we've already dealt with that question. In many cases that will be clear, but in other cases that will be a difficult question because of the factual elements of the advice and guidance given. Advice and guidance given in relation to, for example, a due diligence system will inevitably be complex. It may involve considerable detail. So the question of inconsistency may be a very difficult factual question for the Secretary of State to answer. The final question refers back to what is correct. If you have got the law wrong as a primary authority, your advice and guidance will simply not be upheld, and the Secretary of State should not uphold it, and the courts will be robust in rejecting it, which suggests that it is critically important to make sure that when you advise on a primary authority in a primary authority relationship on the law, that your advice is succinct, clear, and right. So there it is. My view, and I think this is a view shared by Robin as well, is that the referral process, although there has only been one formal referral so far, there is another one in process involving a supermarket, is likely to become a central feature of practice in trading standards, and it's important that trading standards authorities both understand the process and also understand when and when not action can be taken, because if you bring action during a prohibition period, you are likely to find that the courts strike it out as an abusive process, or simply say you didn't have jurisdiction to bring the action at all. Okay.
Brilliant. Well, thank you for that, Jonathan. Whilst you've been talking, we've had a few questions that have come in from the audience. Jonathan, this first one is asked of you.
Right.
It is, trading standards, local authority, inviting is not really a positive thing. Is there any informal process, such as mediation?
The answer to that is yes. The initial stage of a process that is brought before now what was BRDO-RD of a referral process is that there is an attempt by mediation to resolve the dispute without necessity for the Secretary of State to consider it on referral, and so there is ordinarily an attempt, probably very sensible in these circumstances, to resolve the dispute between the two local authorities, or between the business and local authority, before it has to be determined by the Secretary of State. The consequence of that is that the process is slightly delayed, but my understanding is that because of the time limits for resolving the issue, that usually they get on with that fairly quickly.
Great. And second question is, the referral process can take some time. What do you do about time limits expiring?
Well, I think you probably answered that, didn't you, in the sense that time limits are frozen during the period that you are prohibited, that a local authority is prohibited from taking enforcement action. And so while you are prohibited, while there is a reference, time limits do not run. It is important to understand when you are prohibited, though, and when you are not, because the freezing provision only operates when you are, for example, in the 5 working day period where the primary authority is making its decision, or the 10-day appeal period, or on appeal when consent has been given.
Great. Well, I'm afraid I think that's all we have time for, and in any event, I'm out of sherry, so I think we'll call it a day there. Thank you all very much for tuning in. Just before I go, Jonathan, I got this in my cracker. The question is, why did the strawberry get a lawyer?
I don't know, why did the strawberry get a lawyer?
Because it was in a jam. That's terrible. Okay, right. Well, from Jonathan, myself, and from everyone here at Gough Square Chambers, let me take the opportunity to wish you all a very happy Christmas, and we'll look forward to seeing you for the next instalment of Gough Square Live in the new year.
Merry Christmas.
Merry Christmas.